Hello and welcome to SANDEMY. This series explains housing law, standards, and the Renters' Rights Act in clear, accessible language without getting lost in legal jargon or headlines. We're not here to give legal advice or take sides. Instead, we focus on how the housing system actually works in practice for tenants, landlords, letting agents, and local authorities. In this episode, we're looking at the Landlord database and Ombudsman explained, oversight and accountability in renting.
It is good to be back. And this is really the machinery room of the Renters' Rights Act. This is where the gears actually turn.
That is a good way to put it. In our last few discussions, we were looking at very tangible, stuff damp mold, the decent home standard.
Things you can see and touch.
Exactly, things you can physically inspect. But today feels a bit different. We're sort of shifting gears to talk about management, data, and oversight. It feels a bit abstract compared to a leaky roof.
It is more abstract, certainly, but it's arguably just as critical, maybe even more so. You see, if you look at the private rented sector over the last 20 years or so, the biggest problem hasn't just been the physical state of properties.
Though that's obviously vital.
Oh, absolutely vital. But the real core issue has been one of visibility.
Visibility, you mean just knowing what's out there?
Precisely. We know where the houses are, of course, but who's actually pulling the strings? Historically, there's been this huge gap.
In what way now?
In what we know, it's often been incredibly difficult to know who is responsible for a property, how it's being managed, or if issues are, cropping up again and again across the whole portfolio.
I see. So you might have a tenant dealing with an agent who deals with a management company who reports to an owner that turns out to be some anonymous company.
Exactly that. We sometimes call it the ghost landlord problem. And if you're a local council officer trying to serve a notice because, say, a boiler is dangerous, you could spend weeks just trying to find out who to legally send the letter to.
That sounds incredibly frustrating.
It's inefficient. And it can be dangerous. The system's been very fragmented. So the new measures we're talking about today, the Landlord database and the Ombudsman, they're designed to fix that gap. They're the structural backbone of this new system.
Okay, I can see the logic, but I have to play devil's advocate here.
Go on.
When people, especially landlords or agents hear database and Ombudsman, they don't think structural backbone. They think red tape.
More bureaucracy.
Exactly. Great. Another form to fill out, another fee to pay. Is that what this is? Just more paperwork.
It's a fair question, and I get the skepticism. No one wants paperwork for the sake of it, but I'd argue it's much more than that. I mean, regulation without data is just guessing. The core purpose here isn't to create hoops to jump through, it's to build transparency.
Right.
These mechanisms, they're designed to support accountability and, fundamentally, to strengthen confidence in the whole sector.
Confidence for who, though?
For everyone. Tenants, good landlords, local authorities. And it's important to be clear, these tools don't replace existing duties. A landlord still has to fix the boiler.
Of course.
But these tools provide a framework for those duties to operate within. It's about moving from a system that is often reactive and, frankly, opaque, to one that is much clearer and more consistent.
That word framework is interesting. It sounds like we're building a skeleton that the rest of the regulations can hang off of.
That's a good way to see it.
So let's unpack the first part of this skeleton, the Landlord database. What actually is it?
Well, at its simplest, the Landlord database is intended to be a single reliable source of information about landlords and their properties.
A single source of truth.
Yes, because at the moment, we have what you might call data silos.
Right.
You might have some details with a deposit scheme, some with a council licensing scheme in one area, some just on a tenancy agreement. But these systems don't talk to each other. A landlord could be banned in one city and just, set up shop in the next town over.
Because no one would know.
Exactly. The database aims to centralize all that essential information.
Okay, I see the logic in tidying up the data. But in practical terms, what does having this list actually achieve? Is it just a list of names and addresses?
No, it's more of a dynamic portal, not just a phone book. The idea is that essential compliance information lives there.
What kind of information?
We're talking about gas safety certificates, electrical installation reports, energy performance data.
So if I'm a landlord, I'm not just typing in, I own 10 High Street. I'm actually uploading the proof that number 10 is safe.
Precisely. And that achieves three main goals. First, it improves transparency. You know who you're dealing with. Second, it supports compliance.
How so?
By requiring registration to include valid safety certificates, you set a hard baseline. You literally can't complete the registration without proving you meet the standards.
Go ahead.
And third, as we said, it reduces that fragmentation across the whole system.
I want to pause on that second point supporting compliance,
Hmm.
because this brings me to a question I know a lot of our listeners will have. Is this database basically a blacklist?
Ah,
A register of bad landlords that tenants can look up to see who to avoid?
that's a crucial distinction to make, and we must be very, very firm on this. No, it is not a list of bad landlords by default.
That's a really important clarification,
Mhm.
because the fear is that it becomes a kind of public shaming wall.
It's not a pillory in the town square. It is a register of legitimate operators.
Okay.
Think of it more like a driving license or the DVLA database for cars. Just because my car is on the DVLA database, it doesn't mean I'm a bad driver.
It just means you're a legal driver.
It just means I'm a legal driver, I'm part of the system, and I'm accountable for that vehicle.
So if I search the database and I don't find a landlord, that's the red flag.
Exactly. If they aren't on there, they're operating outside the system. Being on the database is a requirement for doing business.
So every landlord, good, bad, or indifferent, has to be on it.
Correct. Now, can it record enforcement action? Yes. If a landlord is given a serious fine, that data will be recorded on there. But its main job is validation, not naming and shaming.
So let's break down the benefits then. If it's not a blacklist, what's in it for everyone? Let's start with landlords. If I'm a decent landlord, I already do my gas checks. Why do I want my name on a government list?
Because it distinguishes you from the cowboys.
Right.
Right now, on a generic website listing, a good landlord looks pretty much the same as a bad one. You can't tell who's compliant just from some nice photos.
Yeah.
The database levels the playing field. It forces the people cutting corners to either step up or get out of the market. If you're a compliant landlord, you want to be on that database because it validates your business.
It's like a verified tick, essentially. It legitimizes you.
That's a very helpful way to put it. It's about professionalizing the sector.
And for tenants, is it just about peace of mind?
It's about the balance of power. For years, tenants have had to hand over huge amounts of personal data to get a flat bank statements, references, the works. But they knew almost nothing about the person they were paying thousands of pounds to. This flips that a little. It gives the tenant the ability to say, okay, before I sign this, is this property actually registered? Does it have a valid gas certificate?
That would also stop those fake landlord scams, I imagine.
Ideally, yes. It just provides that reassurance that their landlord is operating within a recognized framework.
And finally, for the councils, we talk a lot about local authorities, and we know they're often under-resourced. How does a database help a housing officer on a wet Tuesday morning?
Well, this is where it gets really interesting for regulation. It supports what we call intelligence-led regulation.
Intelligence-led regulation. Sounds very official.
It is, but it's very effective. At the moment, a lot of enforcement is reactive. You wait for a tenant to call up because the ceiling has fallen in, or it's random. With the database, a council officer can sit at their desk and look for patterns. They can run a query. Show me every property where the gas safety certificate expired 2 months ago. Or show me every landlord who owns 20 properties but hasn't updated their contact details.
So they can use a sniper rifle instead of a scattergun.
That's the idea. It allows them to use their limited resources where they're actually needed, rather than just casting a wide net.
That seems like a huge win for efficiency. Okay, so that's the database, the who and the where. Let's move to the second mechanism, the Ombudsman. I've heard of them for banks or energy companies. What is their role in private renting?
The Act introduces an expanded role for the Ombudsman specifically for the private rented sector. In simple terms, it is a formal redress route for complaints.
Redress route. Okay, let's translate that. How is this different from, say, going to court or calling the council?
It's significantly different. Going to court is, well, it's expensive, it's adversarial, and it's incredibly slow. It's a sledgehammer. And calling the council is usually for regulatory breaches, things that are illegal or dangerous.
Like severe damp or fire hazards.
Exactly. But there's a massive gap in the middle, isn't there?
What do you mean?
Well, what happens if the dispute isn't about a dangerous boiler, but about poor service? What if the landlord takes 3 weeks to reply emails? What if they unfairly keep 50 pounds of the deposit for cleaning you already did? The council isn't going to come out for a rude email.
No, and a judge certainly doesn't want to hear about it.
Precisely. And that is where the Ombudsman sits. It's for those complaints that can't be resolved directly but don't meet the threshold for, formal enforcement.
It's like a referee.
A mediator with teeth, perhaps. The goal of the Ombudsman is really distinct from the courts. It focuses on resolution and fairness, not on punishment.
That's another key distinction then. We said the database isn't a blacklist. And now you're saying the Ombudsman isn't there to punish landlords.
That's right. The Ombudsman is not a regulator in the sense of handing out criminal fines or banning orders. Their job is to encourage early resolution, to reduce unnecessary escalation, and to provide consistent outcomes.
Okay, give me an example. What does a fair resolution look like if it's not a punishment?
Right. Let's say a repair was delayed. It wasn't dangerous, but the tenant had to buy a small electric heater for a week while the heating was off.
Okay.
The ombudsman might look at that and say, the landlord should reimburse the cost of the heater and maybe pay £50 for the inconvenience. That isn't a criminal fine. It's just putting the tenant back in the position they should have been in.
It's about making it right.
Exactly. And crucially, its decisions are binding. It seems like it fills a massive hole in the system. We have the friendly chat at one end and the terrifying court case at the other, but nothing in between.
You've hit the nail on the head. It's all about proportionality. Most just need an independent third party to look at the facts and say, actually, the landlord is right here,
Yeah.
or the tenant's right, and here's how we fix it.
So we have these two big new pieces on the board, the database for visibility, the ombudsman for resolution. But we still have all the enforcement powers we've talked about before, fines, banning orders, and so on. How does this all fit together? Does this new stuff replace the old?
That is the million-dollar question. And the answer is that it's not an either. They don't replace the old powers at all. Think of it as an ecosystem.
Okay, paint me a picture of this ecosystem.
Well, let's use a traffic analogy. The database is like the DVLA. It makes sure everyone on the road has a license and the car is legal. It lights
Okay.
up the map.
The ombudsman is like the insurance company after a minor bump, sorting out who pays for the scratch on the bumper, making sure it's all fair. It handles the friction.
The day-to-day arguments.
Yes. And the council. The council is the traffic police.
Okay.
They're there to pull you over for speeding, for dangerous driving, for having no brakes. Enforcement is still the heavy artillery. It's absolutely necessary for clear breaches of the law, for ongoing noncompliance, or for serious risks to health and safety.
So if I'm a landlord who's just a bit slow replying to emails, that might end up with the ombudsman. But if I'm leaving my tenants with dangerous wiring, that's still enforcement territory.
Precisely. The ombudsman isn't going to prosecute you for a criminal offense. That's still the job of the local authority. But, and this is key, the ombudsman might flag that issue to the local authority. You see how they connect.
I do. It feels like they're meant to talk to each other.
That is the intention. If an ombudsman gets 10 complaints about the same landlord for severe damp, they won't just resolve them one by one. They're going to flag that landlord to the council. And if a council sees a landlord isn't on the database, that's an immediate trigger for them.
It creates a loop.
A closed loop, yes. Together, they support a much more proportionate and targeted regulatory approach. It means we don't have to use a sledgehammer to crack a nut, but we know exactly where the sledgehammer is if we need it.
Proportionate and targeted. I like that. But let's look at the practical implications, the why it matters. If I'm a good professional landlord, how should I view all this? Because honestly, it still feels a bit like more work.
It will be a bit of administration up front, yes, that's true, but you should really view it as a validation of your professionalism and a massive risk reduction exercise.
Risk reduction.
Because these mechanisms reward good practice. If you keep accurate records, if you manage your properties well, if you engage early when there's a problem, these systems work for you. If a tenant makes a baseless complaint to the ombudsman and you can show your paper trail, the ombudsman will rule in your favor.
So it protects you from false claims, too.
Absolutely. It's about demonstrating compliance, not just worrying about getting caught. The database confirms your legitimacy. The ombudsman resolves disputes before they become costly court cases. It makes oversight part of standard professional operation rather than something to be afraid of.
And for tenants, what does that reassurance look like on the ground?
It means knowing that if you raise a concern, there's a recognized route for it.
It brings consistency, too, doesn't it?
Huge consistency. A tenant in Manchester should have the same access to redress as a tenant in Bristol. For a long time, renting has felt like a postcode lottery, depending on the local council. This standardizes things.
And finally, for the councils themselves, it helps them make better decisions.
Yes, because they aren't flying blind anymore. An officer can check the database, see the history, see the context, and knowing the ombudsman is there to handle the lower-level disputes allows them to focus their limited resources on the worst offenders.
It clears the decks for the serious stuff.
It allows them to triage. It's the only way to make the sector safer with the resources available.
It really does sound like a maturity moment for the private rented sector, moving from a sort of cottage industry to a professional, regulated service.
That's a very apt way to describe it. It's about acknowledging that providing a home for someone is a significant responsibility. It's a service. And services need transparency and accountability.
Well, I think that clarifies a huge amount. We've gone from more red tape to understanding the skeleton of the new system. We know the database is about visibility and verification, not blacklisting.
Right.
And we know the Ombudsman is about fair resolution, not punishment. And enforcement is still there for the really serious stuff.
That's an excellent summary.
So now that we understand the tools, the what and the why, the next logical question is when? When does all this start?
Ah, yes, the timeline. That is the million-dollar question, and it's not as simple as day one.
It never is with legislation, is it?
No. The next episode is going to be crucial because we're going to look at implementation and transition. We'll discuss how the system comes into force, the phased rollout, and, what preparation actually looks like for everyone.
Getting your ducks in a row before the starting gun fires.
Indeed.
That brings us to the end of this episode of SANDEMY. We hope this has helped explain how this part of the housing system works and why the changes matter in practice. This content is provided for general educational purposes only, does not constitute legal advice, and is not published on behalf of any local authority or organization. For specific situations, always refer to the legislation or official government guidance. If you'd like to follow the rest of this series, you can subscribe to the channel for future episodes. In the next episode, we'll look at when does the Renters' Rights Act start, timelines, transition, and how to prepare.